All right, so when you hear the phrase Uniform Evidence Acts, I bet your eyes start to glaze over, right? It just sounds like the driest, dustiest rule book on the planet. But what if I told you it's not really a rule book at all? Think of it more like a living thing, a legal framework that's actually breathing, growing, and changing every single day in courtrooms all over Australia. Let's dive in.
And this really gets to the heart of the whole thing. The dream was simple, one single set of rules for everybody. But here's the reality. A law isn't just words on a page, is it? It gets used by real people, judges, lawyers, in different states, with completely different legal cultures and histories. And that tension, that friction between a uniform law and non-uniform people is what makes this whole topic so incredibly interesting.
Okay, so here's what we're going to cover. We'll start with the dream of uniformity. Then, we'll talk about judges as the law's interpreters. We'll look at why old law still matters, check out the Evidence Acts toolkit, and wrap up with why this is truly an unfinished story.
All right, let's kick things off with that big dream of uniformity. I mean, just think about it. Trying to get every state and territory in Australia to agree on, well, anything is a huge, huge task. But that was the ambition here. One single, logical set of rules for evidence in court, whether you're in Sydney or Perth or Hobart.
You see, before this, evidence law was just a total mess. It was this crazy patchwork quilt of old common law principles mixed with a bunch of different state-specific statutes. It was confusing, it was inconsistent, a real headache. So the Uniform Evidence Acts were supposed to be a total clean slate, a single, modern, and, this is key, a clear law to replace the whole tangled web.
Okay, so that was the dream. But this is where it gets complicated. You can write down a uniform law, sure, but can you create uniform judges? No way. The second this act hit the courtrooms, it stopped being just text and started being shaped and molded by the real people using it. Let's look at how that actually happens.
You know, judges don't just passively apply this law. They're actively building it, and they do it in 4 main ways. First up is just basic construction. They have to figure out what the detailed sections actually mean. Second, they preserve bits of the old common law where the act is silent. Third, they have to clarify really general terms. I mean, what does something like unfair actually mean in a courtroom? They have to define that. And finally, and this is a big one, they use their discretion. They create the guiding principles for all the different powers the act gives them. You're literally watching the law evolve.
And look, this isn't just some abstract legal theory. This happens for real. Take Section 137. It's a rule that lets a judge toss out evidence if its power to prejudice the jury outweighs its actual proof value. So, if it's more likely to make the jury hate the defendant than to actually prove a fact. For years, New South Wales courts read that section one way. But then, Victoria adopted the same law, took one look at the NSW approach, and basically said, nope, that's plainly wrong. And they came up with their own totally different way of interpreting it. Same words on the page, completely different results in court.
So how is that even possible? How can a uniform law be different in 2 places? Well, it comes down to this legal idea called the plainly wrong doctrine. The general rule is, courts in different states should follow each other's rulings to keep things consistent. Unless, and this is a huge unless, a court is absolutely convinced the other court's decision was plainly wrong. It's kind of funny, right? It's a rule that's meant to create uniformity, but it has this massive escape hatch built right in that lets the differences continue. All right, now this leads us to something that sounds like a total contradiction. You'd think, okay, we've got this shiny new act meant to replace all the old law. We can just toss out all the old history books, right? Wrong. Turns out you absolutely cannot understand this new law without constantly looking over your shoulder at the old one.
And the High Court of Australia just nailed it with this quote. A new law, a statute, it doesn't just materialize out of nothing. It's written on top of a foundation of existing legal concepts. And like they say here, that old common law, it almost always gives you the key to understanding what the new statute was even trying to achieve in the first place.
So when exactly are judges allowed to crack open those old law books? Well, there's a whole bunch of good reasons. They might need to understand the mischief. That's the legal term for the specific problem the new law was designed to solve. Or maybe the new act uses an old technical term that only makes sense if you know its original meaning. And really importantly, they look back to get a handle on the principles behind all those discretionary powers we were talking about, like Sections 135 and 138. It's all about context.
Okay, so we've talked about the big picture, the philosophy, the judges. Let's get down to brass tacks. How does this thing actually work in a courtroom, day in and day out? Let's look at the actual toolkit, the machinery of the act.
So the Act's day-to-day machinery really boils down to three main things. First, you've got notices. The idea is no ambushes. If you're going to use something complicated like hearsay or tendency evidence, you have to give the other side a heads up. Simple. Second, there are requests. This is just the formal system for asking the other party to call a certain witness or hand over a document. And third, the one we keep coming back to, discretions. A massive, massive range of powers for the judge to manage the trial.
And I can't stress this enough. This is the core philosophy of the entire Act. It is just jam-packed with these discretions. Instead of trying to write a super rigid rule for every single thing that could possibly happen in a trial, which is impossible, the lawmakers decided to give judges flexible powers. It's a system that's fundamentally built on trusting judges to make the right call.
Now, what kind of powers are we talking about? Well, for example, a judge can literally halt a trial to order a demonstration or an experiment. They can even take the entire court on what's called a view, an inspection of a location, like a crime scene. It's pretty amazing, and it's all about helping the court get a real feel for the evidence.
Or how about this one? The power to exclude evidence just because its use would be unfair to the accused. Think about that. That's not some tiny technical rule. That's a huge judgment call rooted in fundamental ideas of justice. This is exactly what it looks like when a law puts its trust in the hands of a judge.
So, as we start to wrap this up, there's one last really important thing to get our heads around: what the Uniform Evidence Act isn't. Yes, it's a massive piece of legislation, but it was never, ever meant to be the final word on everything. There are huge chunks of evidence law that it just doesn't cover. On purpose.
I mean, just take a look at some of the big topics it leaves out. Things like the prosecution's duty about which witnesses to call, or the rules for making a no-case submission to get a case thrown out early. It doesn't even touch on huge legal doctrines like res judicata, the basic idea that once a case is judged, it's done. All of that stuff still lives in the old common law, in this sort of legal hinterland that operates right next to the Act.
And that, right there, is probably the single biggest takeaway from all of this. The Uniform Evidence Act isn't a finished, sealed-off code with an answer for every question. It's a framework. It's the foundation. But it lives and breathes inside a much bigger legal ecosystem, one that's full of common law, court practices, and legal culture.
Which brings us back to our first question, really. Is a uniform law some kind of finished product, a final destination, or is it something else entirely, the start of a never-ending conversation between the people who write the laws, the courts who interpret them, and the lawyers who use them every day? It seems pretty clear this law doesn't just sit on a shelf. It really does breathe.